Okay, cool. So, hi everyone, I'm Patricia. I just noticed my name is Danielle here, but I'm a startup CPG. You have seen me in the Slack. Today we're going to have a awesome webinar with Lauren and Danielle. They're going to talk about if you're ready for a recall. They're going to explain a little more about that and introduce themselves. So, Lauren, if you can introduce yourself, that would be great.
Sure. Hi, I'm Lauren Handel, and I have a law firm called Handel Food Law, which, as it sounds, specializes in food businesses. So I provide a variety of legal services to food businesses. A lot of them are very small. A lot of them are like many of the members of the startup CPG community. And most of what I do is regulatory compliance, also a lot of contracts and a lot of trademark work. I'm gonna let Danielle introduce herself before we get into the presentation.
Hi, everyone. I'm Danielle Holyoke. I am CRO and co-founder of Amelia Risk Insurance Brokers. We are CPG insurance brokers, so we handle all lines of commercial insurance for anyone in the CPG space.
Awesome. Thank you. Well, I'm going to kick off. I'll let you guys start your presentation, and just one note before, we are going to do the Q&A at the end. And if you have any questions during the presentation, you can use the feature down here, is the Q&A feature. So that's the best way for us to track all the questions, but feel free to use the chats to, talk to each other or drop any other messages that you want. So yeah, I'll let you to handle this now.
Okay, so everybody can see the presentation? Yeah, okay, good. So we called this, Are You Ready for a Recall? But it's not going to be like some other presentations you might have seen or content that's out there, which is really about the nuts and bolts of how you prepare from an operational standpoint for a recall. Instead, our focus is really on, do you have the information that you need, and have you taken the steps that you can take to mitigate the downside of a recall? The reality is that recalls are pretty common in the food industry. Even really small brands have sometimes pretty complicated supply chains and don't have total control over how their products are made or the ingredients in them, and things can happen. And so if you're in the business long enough, chances are at some point you will face a recall situation, and it can have really big negative consequences. So what we want to talk about today is what are some things that you can do, and what do you need to know to try to minimize that negative impact as much as possible. So to throw out some scenarios, imagine this. You might get a customer complaint that someone got sick or injured after eating your product. You might get lab results back from finished product testing that are positive for salmonella or some other pathogen. Maybe you get a supplier notification that milk or another allergen has been detected in the ingredient that they supplied for use in your product, but that allergen is not declared on your label. And that's actually the most common reason for recalls, is the failure to label allergens. Or another situation might be that your co-manufacturer accidentally used the wrong ingredient. My hypothetical situation here is they incorrectly used GMO soy sauce, and your product is labeled as a non-GMO product. Maybe it's non-GMO verified. So obviously that's an out of spec product, but different than the other situations in that probably no one's getting sick as a result of that. It's not likely to cause injury to consumers. Nevertheless, it is a problem. So when I'm using the term recall, I will tend to use it in this presentation for two different situations, only one of which is technically considered a recall, at least from a regulatory standpoint, right? So under the regulations, a recall is a situation where there's a product that violates the law. There is something wrong with it from a compliance standpoint, And that problem is one that FDA is likely to take enforcement action on. So it's a serious enough problem that if nothing is done about it, FDA would take action to seize the product, remove it from the market. There are other circumstances that are referred to as market withdrawals, although again, I'll probably use the term recall interchangeably. But in that case, and the definition of a market withdrawal is another circumstance, such as it's a minor violation that FDA wouldn't take enforcement action on, or there's no violation, but still the responsible party needs to remove that product from the marketplace. There are different classifications of recalls, and they relate to the hazards associated with the product. So class 1 recalls are situations where there's a reasonable probability that the product will cause serious adverse health consequences or death. Obviously, that's the most serious type of situation. Undisclosed allergens fall into that category. Pathogenic bacteria in ready-to-eat products falls into that category. Class 2 recalls are ones where there's a remote possibility of serious adverse health consequences, or that the health consequences are less serious. They're temporary or they're medically reversible. And class 3 recalls are ones where the product is not likely to cause adverse health consequences. So it could be a significant labeling issue that could cause consumer deception, a materially misleading label, but it's not something that would have adverse health consequences. And the categorization or the classification of a recall relates to how deep the recall needs to be, right? So a class 1 recall generally has to go all the way to the consumer or the end user level. If consumers if the end user is a manufacturer, and it's a class 1 situation, the notification and the efforts to remove the product have to go all the way to that level. Class 2 recalls generally have to go to the retail level, and class 3 recalls generally only have to go to the wholesale level. So what will you expect to be doing if you're in this situation? You've gotten that consumer complaint or the bad lab results. I've outlined these steps. Recognize that this is not necessarily a series of events, right? Some of these things are happening at the same time, and they don't necessarily all happen in this order, but this is the basic flow of what happens. Number 1, as soon as you know you've got an issue, even before you're sure what the issue is, you want to maintain the status quo as much as possible. You want to halt manufacture and further distribution of the product, at least until you can figure out what's going on, right? You don't want product that might have a problem to continue to go out into the marketplace until you can at least get a handle on what the situation is, identify the affected lots, segregate them. So just pause as much as possible so that you can figure out what the situation is and come up with a plan. Assemble a recall team, right? So you should have a plan in advance for who these people are, and they should know that they are going to be on the recall team, and they should know what to expect and what their roles will be. But you need people who can make decisions for the company, people who have sufficient information about the products, about the operations, about the distribution, about the legal consequences of everything, about the PR. So get those people together, and you're going to come up with your plan for assessing the problem, assessing the hazard, how you would classify this situation, and investigating the cause. And the investigation is likely to go on while the recall is happening, but as best you can initially, you want to figure out, what is this problem that we have? Are we in fact in a recall situation? How serious is it? And what do we think is the cause? Notifying FDA. So there are situations where FDA must be notified, And that's if you're in a class 1 situation, you know that you're in a class 1 situation, the responsible party has 24 hours to notify FDA. FDA also requests that companies voluntarily notify FDA recall coordinators whenever they're conducting a recall. And so FDA can actually be very helpful in helping to make sure that you have a good recall strategy, to make sure it's an effective recall. And they ask, but it's not required that you notify them. You want to take action and develop a strategy to remove the product from the market. So you need a strategy for how you're going to get the communications out, what you're going to ask customers to do, and how operationally you're going to remove the product from the market. FDA is going to want to know what that strategy is and can give input on that strategy. Then you're going to want to notify all the affected accounts, right? So you need to know who all the buyers are, notify all of your direct customers. So if you sell only to distributors, you at a minimum have to notify them. But if we're in a situation where this is going to be a recall that goes down to the consumer level, then a press release probably is also necessary, and some other public communications. If you have e-commerce sales and you know individual consumers who purchased your product, you're probably going to need to notify them directly as well. And then after the recall has been implemented, you'll need to evaluate the effectiveness of it. And so that involves actually making phone calls or sending questionnaires to the customers that you've notified of the recall to verify that they've done the things that you've asked them to do, that they've accounted for the product that they had, that they've returned it to you, or in some cases it's appropriate to destroy it. And then FDA will want updates on the status of the recall and your effectiveness checks. And then eventually this will come to an end. So when you've reached the point where you've done all you can reasonably do, reasonable in connection with the level of hazard that's associated with the problem, and things like the shelf life of the product, right? So if we get to a point where you've done the most you can reasonably be expected to do to get the product off the market and the hazard doesn't really exist anymore, then the recall can be terminated, and you want to make sure that that gets reflected in FDA's recall records, that it's been terminated. So I just wanted to give some background to understand what are the legal obligations that you have when you're in a situation like this. And then next, I'll talk about what potential liabilities you have. But so I covered some basic hypotheticals, and most of them involve situations where you have a product that could cause harm to people. All of those situations would be considered defective products. That can be because there is some adulterant, there's some contaminant in a product. That would clearly be a defect. A defect also can be a failure to give a warning. So the absence of an allergen disclosure can be considered a defect. And under general law of product liability, everyone has a duty not to sell defective products. And this is strict product liability. So it's important to understand that even in situations where your company, your manufacturer, anyone in the chain of commerce of the product has done everything that they reasonably should do, no one is negligent, sellers of the product can all be held strictly liable under the law. So if it's not your fault, you may have a claim against the party whose fault it was to be indemnified for whatever losses you end up having to cover. But still, the consumer who's injured can come after you under a strict liability theory to recover for their injuries. Under food law, under the Food, Drug, and Cosmetic Act and the state counterparts to that law, you have a duty not to sell. There's a prohibition against selling or distributing adulterated or misbranded food. So if the product is non-compliant, it is illegal to distribute it in commerce. I mentioned this before, the notification to FDA. So there is a obligation of the responsible party, which in this case doesn't mean the brand owner necessarily. It means the entity that registers the facility where the product is made or held. If that entity becomes aware that it has a product that is in a class 1, a reasonable risk of serious adverse health consequences situation, within 24 hours of determining that, it must report that to FDA through its reportable food registry. And then there's also contractual obligations to think about, right? So you have contracts with customers and with suppliers, and these can include things like indemnity obligations, obligations to give notice and information and to buy back product and to cover expenses, confidentiality obligations, right? So all these things have to be considered as you're assessing and responding to this incident. Potential liabilities that you could face. So if people are injured, they could have personal injury claims. Again, this is strict product liability, right? So these are claims to recover for their injury, their loss of income, their pain and suffering, potentially death. Breach of contract and warranty claims could cause liability, right? So I mentioned you have obligations to your customers. If you don't honor those obligations, then they might sue you for breach of contract. And then there's regulatory and criminal enforcement. The criminal enforcement is very unlikely. It's very rarely used and only used in the most egregious circumstances. But the regulatory enforcement risk is a very real one. And that can be that as a result of the recall, FDA becomes aware of an issue with your product or your operations and takes some kind of enforcement action. So what can you do to minimize the fallout of this type of situation? The most important thing, and it's always keep this top of mind if you're in this situation, the most important thing you can do to protect yourself is to prevent the problem from spreading and protect consumers from harm. Do what you need to do as quickly as possible to keep people from getting injured. There is never a situation where that's going to cause you more harm. It will always help both the reputation of the company and to minimize the amount of damage that can come out of an event like this. So above all else, protect consumers as quickly as you can, as effectively as you can. So obviously there's also things you can do in terms of quality assurance and making sure you have good traceability. Those are things for someone other than me to talk about, but even if you don't manufacture your own products, it is really important that you have people with QA expertise, food safety expertise on your team, whether that's an employee or contracted out, but someone other than your co-manufacturer who is on your team that you can rely on to make sure that the co-manufacturer is using good QA procedures, that you have those enforced in your contract through your product specifications, that you have good traceability systems in place so that you can minimize the extent of the recall to the product that's affected and not more than that. You should also have a written recall plan and practice doing recalls. And I'm sure there are many brand owners who think that's overkill if they're not making their own product, but ultimately it's going to be your responsibility. It's your brand on the product that's out there getting recalled, and it's your customers who are going to come back to you with their complaints and their demands to be repaid and for you to buy back product. And so you're going to have to respond in that situation. And it is always a kind of hectic situation where there's a lot that needs to be decided quickly. So the more you can have things planned in advance, know who's going to do what, have templates for the customer communications that are going to go out, know exactly how you can contact each of your customers. They will all have their preferred ways of receiving notice of recall situations. Like, have all that information at your fingertips so that if and when the circumstance happens, you're not scrambling to try to figure it all out. Compile and understand all the contractual obligations that will be triggered in a recall situation, right? So I've mentioned that your customers have, in the contracts that you have, you know, the vendor terms that you agree to, even if you didn't sign something necessarily, when you sell a product to a major retailer, you are agreeing to their vendor terms. And I just pulled off the internet, just as an example, Albertsons recall policy, which again, you agree to this if you sell a product to Albertsons. And it says that their suppliers will be responsible for the timely notification of the recall to Albertsons companies, the cost of the goods recalled or withdrawn, the recall withdrawal logistics costs, which are defined to include handling, shipment, transportation, disposal, environmental, and customer notice expenses, as well as administrative costs, and the applicable administrative costs. And you know, they even say how they come up with these administrative costs. So you have obligations like that. You look in your distributor agreements, you know, if you work with UNFI or 𝐀𝐁 or any other distributor, look in the contract and you'll see that there are obligations to give them notice within a certain amount of time, to share certain kinds of information about the situation, and to indemnify them and hold them harmless of the costs that they incur to buy back the product, the same kind of thing that's in the Albertsons terms. So know what all of those obligations are. Ideally, you can integrate a summary of them or cross references to them in your recall procedure. So again, it's at your fingertips and you'll know what exactly you have to do so you don't risk breaching those contracts. Assume that there will be litigation. And I say that not because I think that recalls always lead to litigation or even lead to litigation most of the time, but there is a large potential for litigation. And that could be because injured consumers sue you, because your customers sue you, or you need to sue one of your suppliers, or you need to sue your insurer for coverage dispute. Just assume that litigation will happen that will relate to the facts of the recall situation, and therefore evidence is going to be important. You have a duty whenever there's the possibility of legal claims to preserve potentially relevant evidence. The consequences for not doing so can be really severe and it can really harm you in litigation. So make sure you're preserving all potentially relevant evidence. At the same time, you're creating evidence as you're investigating, as you're receiving information from customers. You want to be mindful about the evidence that you create with the idea that it may be discoverable one day in litigation. So if possible, and you know, where appropriate, if there are issues to be investigated about the cause of the recall, and if that can be done under attorney-client privilege, then that will help to protect that information from discovery and can be a very useful way to be able to kind of more freely investigate different possible scenarios without having to worry about how that information might end up getting used against you in litigation. And when I say that, conducting an investigation under privilege, that means having an attorney for your company oversee the investigation, hire the outside consultants so that the investigation is being done for purposes of providing legal advice to the company, and then it will qualify as privileged. You want to be documenting communications with customers. So especially if you're getting complaints from customers and at some point those might be legal claims against the company, you want to make sure that the people who are fielding those complaints get good information from the customers. Exactly what product was it? What information was on the label? Exactly what did they experience as a result of consuming the product? What what symptoms did they have? Did they see doctors? Like, try to get the facts as much as possible so that you have a record of that. And if later on it ends up turning into a legal claim, you can compare those things compare what is being said later to the information that you got near in time to when the issue first arose. You want to be keeping good records and documentation of all of the expenses and losses that you're suffering, and this will become especially important if you need to make insurance claims and if you have insurance coverage, Danielle's going to talk about, but also if you have claims against other parties who caused whatever issue it was that triggered the recall. And you want to also be really mindful and careful about external communications. So I mentioned that it's important to notify FDA. FDA is going to have a lot of questions for you, and it's going to actually require that you fill out forms providing all kinds of information about the product, about the circumstances that led to the recall, what you think is the cause of the recall, what you're doing in response. And it's important that that information is provided freely, but very factually. You don't want to create a record of information that turns out to be incorrect, that you're later going to have to do a lot of work to explain around and correct. So you want to have only factual information out there. You want to not speculate. And so it's really important that the people that are responsible for those communications with outside parties are really careful. Attorney review of those communications can be very helpful. And also just be aware that a lot of that information will become public. So when you're filling out these forms that FDA is going to request that you fill out when you've given them notice that you have initiated a recall, that information can end up on a publicly available FDA website. And so you just want to have all of that in mind. Expect follow-up regulatory action. So based on, and again, this gets back to think carefully about what you say. FDA might issue a warning letter just based on the information it learned in the recall. Remember, recall is a situation where the product is non-compliant, it violates some rule, and FDA could just, as a result of that, issue a warning letter, which is its main enforcement tool as a result of learning that information. The recall situation also might prompt FDA to conduct a for-cause inspection, which could lead it to find other problems. So you want to be prepared to show that any problems that have surfaced in this recall situation have been corrected or are in the process of being corrected, and that you've truly identified what the root cause was and are taking care of it. Consider recalls in negotiating supplier contracts. So this is, it's kind of stepping back in time before the recall situation. When you're negotiating with your co-manufacturer for your contract, or in some circumstances, probably not very common for small brands when they're buying from larger ingredient suppliers, but in some cases you might have smaller ingredient suppliers where you actually do have a contract with them and there's some room to negotiate. At a minimum, there should be, especially in a co-manufacturing agreement, language that requires the parties to work together when they're in a recall situation. So you want a contractual obligation that you're going to share information with each other, cooperate with each other, because you're going to need that. It also would be beneficial to have language that gives the brand owner the right to control the recall as much as possible, being mindful of the fact that your manufacturer has its own legal obligations in this situation, right? The manufacturer is that responsible party who's required to notify FDA within 24 hours, right? So it has its own legal obligations and compliance burdens, but to the extent possible, as the brand owner, you want to be in control of the communications about the recall and what the situation was that led to the recall. The contracts can and should provide for indemnities, right? So as much as you can get protection from your suppliers in the form of indemnities for recall situations, then that is good and can be helpful. And this could be both indemnities for third-party claims. So a consumer who is injured sues you for a problem with your product that was caused by your manufacturer or an ingredient supplier, having that contractual right to go back to that supplier to cover the losses and liabilities and also to defend you in that situation. That's third-party indemnity. Direct claim indemnity is the contractual agreement that the supplier is going to cover your direct losses as a result of the recall. I'd say that's less common, but if you can get it, by all means, try to get it. You want to look really closely at the language in the contract that talks about exclusive remedies for any sort of non-conforming or defective product or breach of warranty situation, and the limitations of liability, which would very commonly exclude a lot of the costs that you're going to have that would fall into the category of consequential damages or incidental damages. So things like paying for Albertsons shipping and disposal costs, right? Those are going to be consequential or incidental damages that might be excluded from your manufacturer's liability under the contract. The damage to your reputation and loss of profits, those also might be excluded in the limitation of liability in the contract. And then insurance requirements. Ideally, everyone has insurance, but you'll want to look closely at what kinds of coverage the policy requires each party to have. Does it include recall insurance? Danielle's going to talk about recall insurance. It is becoming more common, but I will say that in the contracts I see, it's not very common to see. So it is always something to think about. And if both parties have adequate insurance, then they can be much more comfortable that there is going to be coverage for the kinds of losses that likely can result. And my last tip, and this turns it over to Danielle, is get the best insurance that you can afford to have.
Thank you. So yeah, so insurance, product recall insurance. What is it?
Sorry.
Thank you. So it's an insurance policy intended to make you whole in the event of a recall. So insurance is a transfer of risk. It's one risk mitigation tool. This type, and that, Lauren just went over a bunch of different ways you can mitigate your risk. And insurance is just one of those. So these types of policies can be really broad. Just like with any insurance policy, the value of the policies can vary from insurance company to insurance company, and the devil is really in the details. So the benefits of having a policy, you're transferring the risk to a third party, right? You're paying the insurance company a premium, they take on the risk, they will pay you in the event of a loss. It protects your balance sheet, and it fulfills the contractual obligations you have to indemnify customers in the event of a recall. So what triggers the policy? In order to have the product recall policy triggered, one of these following things needs to have happened. And the real big key piece here is it would need to result in bodily injury or be already causing bodily injury. For the purposes of this, I'm going to say bodily injury, but it can also include property damage. It's just that for consumable products, bodily injury is, of course, the biggest concern. So these are the policy triggers. And they are separate from the legal classification of the recall. So whether it's a class 1, 2, or 3, the insurance policy doesn't necessarily care about that, right? What they care about is, if you have this product in the market, will it harm someone? Will it cause bodily injury? If yes, then that triggers the policy. So you have accidental contamination, malicious tampering of a product, a government mandated recall. There's the government advisory. So if the government advises about not your brand or not your product, but maybe it's a competitor's that is similar or identical to yours, and you need to also recall. There's product extortion. And then, of course, adverse publicity. So this is when there are reports, media reports of your product harming people or potentially being harmful. And that can include social media reports. And again, these things have to happen, but it also has to be, there has to be a risk of bodily injury happening if that product stays in the market. So what does the policy pay for? So again, this can be a very broad policy. Some policies are great, some are good, some are not so good. And it really depends on that you buy most for recall. So cost to take the product off the shelves, out of the market, to destroy the product or dispose of the product, pays for replacement costs, your loss of gross profit due to this recall, extra expenses like paying employees overtime to work on this recall, brand rehabilitation, so working with a PR firm to manage the message to consumers and rehabilitate your brand when necessary, defense costs, investigation costs to determine if a recall is necessary. These policies come with consulting. So there's pre-incident consulting, which means that when you buy the policy, you can work with a team of experts that the insurance company chooses. They use kind of their panel of different crisis consulting groups that they've determined are good for various types of products. And that team can help you come up with a product recall plan. They can help you draft it. They can work with you to put those procedures in place before a recall even happens. And then there's crisis consultant costs covered by the policy. And that is when a recall happens, you have these consultants that work with you to manage this recall and help you figure out what it is that you need to do. The costs of those consultants is in addition to the policy. So that is something that this service just comes with purchasing the policy. And then importantly, Lauren was just mentioning this, the third-party coverages are often included in a product recall policy. Third-party coverages are customer recall costs. So in the scenario we were just talking about where Albertsons, has to pull things off the shelves and deal with it on their end, their costs to dealing with your recall, their loss of profit, and their brand rehabilitation are all included under a recall policy. I'm going to talk about some common exclusions. So insurance policies are not intended to be these end-all be-all limitless buckets of coverage, right? They are intended to be covering very specific things and excluding very specific things. So a couple of exclusions I want to talk about that I think are commonly misunderstood or not assumed that there would be them in the product recall policy. Expiration of your product or the natural deterioration because of a shelf life. The product recall policy is not going to insure you against your product expiring and harming people, right? Things tasting bad, or the color or texture is off, or it smells really gross. That type of scenario is not covered under a recall insurance policy unless it would cause bodily injury to a third party if it was remaining on the market. So this has come up with a lot of my clients before. I had a client who had a drink with a coconut water base. And the question was, can we get recall to cover this scenario where coconut water just, sometimes it doesn't taste good, sometimes it smells really bad. Can we get a recall policy to ensure that? And the answer is no. You can't get a recall policy because your coconut water drink tastes nasty. It has to be potentially harming someone in order for the recall policy to respond. And lastly, on the exclusions, product liability. So product liability is a component of general liability that is a separate policy altogether. And they, I think, are often a little confused, or people wonder where one begins and the other one ends, right? Product liability is coverage for third-party claims of bodily injury and property damage, but not the cost to recall the product in the case of bodily injury. So these policies often work alongside one another, but not together. They work alongside one another in the same event. You have product hurting people, but they are not the same policy, and you don't have coverage for both under one policy. So they're very separate in that way. So whose policy responds? Let's say you have a recall and you have an insurance policy, good for you. Whose policy responds, right? You have a contract manufacturer who may be responsible for this. Ultimately, the brand's recall policy is going to respond to a recall the brand needs to perform. Any ability for the insurance company, for your insurance company, to subrogate against the responsible party, for instance, the ingredient supplier or the co-man, they're going to do that. They're going to assume that. They reserve the right to go after and recover payments that they make. And they're pretty good at it. They've got a whole team of people that work on that. But your recall policy is first and foremost going to respond to recalls that you need to perform because you are the brand, right? And notification. So, there are legal obligations, as Lauren just talked about. When you buy an insurance policy, you have obligations to an insurance company as well. They're pretty vague. And that is that you need to notify the insurance company as soon as practicable. If they find that you did not notify them when you did know about it and there was late notice, there could be penalties, because the goal is that the insurance company gets involved at the very beginning to help minimize any damage done. If you end up not renewing the policy, or you don't carry it anymore, there are drop dead dates that you can submit a claim, and it's usually 30 or 45 days after the end of the policy, but that depends on which carrier you're with. And then there's crisis consultant hotlines available 24/7. Again, this service comes with the policy because their goal, the insurance company's goal, is to pay as little as possible, right? That's everybody's goal, but they're available. When you call, they can help you work through, is this a recall? What steps do I need to take? And they'll help deploy a team to help you manage the recall. You want to give them all known information at that time, because that helps them determine what they're really working with here. And hopefully you don't have to ever use this policy, right? That's the goal, is that you have insurance policies for really bad situations that happen, but hopefully you never have to use them. Hopefully you don't find yourself in the middle of this. But in the event that you are, you want to have good protection, and they're pretty commercially reasonable these days. I think, in the grand scheme of insurance, recall is a fairly new policy. And when I say new, I mean probably 2 decades, 3 decades old. And so there are a lot of competitive markets available for, small startups that used to not be totally available. So that's insurance.
Thank you. Let me just fix one here. Okay. Thank you. That was a lot of information. I appreciate you guys sharing that. We do have some questions, but feel free, guys, to use the Q&A feature here, and we're going to respond all of them. Just to start one, like, the recording will be available probably by tomorrow. We'll send an email to everyone their RSVP with the link to watch. But if you don't get it, just Slack me and I can send you the link as well. Okay, so do you guys want me to read the question, or you guys want to read the question?
Yeah, so I answered one, I typed an answer to one, which is I can just do real quickly, which is basically on the scope of FDA's jurisdiction. So just real quickly, FDA has overall responsibility for all food except meat, poultry, catfish, which is a weird thing, eggs that are not in a shell, and alcoholic beverages. So all other food is FDA, and food means conventional foods and beverages, but also dietary supplements and chewing gum. So that was a pretty quick question. There's another question on the issue of a responsible party. So I just want to be clear about, I use the term responsible party, which is a defined term in the regulations as far as who is responsible for notifying FDA. And in that circumstance, it would be the manufacturer. It's a party that actually registers with FDA because it has a facility that manufactures, processes, holds food. So many brand owners don't even touch their product ever, except when they get samples occasionally, right? And they would not have a food facility that gets registered with FDA. And in that sense, they're not a responsible party. But make no mistake about it, legally, the brand owner is a responsible party for its product. I talked about strict product liability. Anyone who sells a product that is defective can be held strictly liable. So even if you didn't make the product, you didn't choose who to source the ingredients from, you didn't test the product, you didn't do anything wrong. If it's defective and it hurts people, you will be held responsible. So just wanted to clarify that point. The other part of this question is there insurance or contracts that should be in place between between the brand and the co-packer to protect the brand? Or is the co-packer ultimately responsible? Yes, there should be contracts. There should be contracts that make this clear. By default, under the law, if the co-manufacturer is the source of the problem, right? They fail to adequately sanitize their equipment and therefore a pathogen got introduced into your product. Well, eventually, when everything shakes out and gets litigated and all the facts are known, they might be held responsible and have to pay you back. But in the first instance, it's your product. Consumers are going to sue you if they get hurt. And so you will need to have that recourse against the manufacturer. And it would be very beneficial to have a contract that makes clear that the manufacturer will cover you in those circumstances, indemnify you, defend you, carry assurance that names you as additionally insured, so that you don't necessarily have to go through all of the steps of litigating and proving everything that went wrong.
Yeah, and just on that note with insurance, everyone needs to have their own insurance. Your contract manufacturers likely have their own insurance. Most of them do. Do they have enough? I don't know. Do they have good policies? I don't know. Are they going to use them? We don't know. You need to have your own insurance so that you can be made whole. Like Lauren said, when it all shakes out and you might at the very end have that contract manufacturer being held responsible, but how much money are you going to go through before you get to that point? And like they said, when I buy something at Target that, causes me an illness, I'm not going to try to figure out where that brand may have had who their contract manufacturer is, right? I'm going to come back to the brand and probably Target as well. So it is so important that even if you're using a contract manufacturer, that you have your own insurance, because it's your label that is at risk here.
And then talking about responsibility has another question that they ask if package designers ever sued in recalls, because of like what they claim in the label and artwork.
The designer of the package, not that I know of. So ultimately it's the brand whose name and address is on the package that's going to be held responsible for the content. I suppose there could be some theory if the designer wasn't just a designer, but was actually giving advice about like claim substantiation, and that turned out to be bad advice, and the brand relied on that. Like maybe there would be some theory, but I think it's pretty far-fetched. I'm not aware of a situation where a designer was ever held responsible for something like that.
Okay, thank you. And do you have recall opinions or advice about packaging, labeling? I'm especially thinking of front and back label claims.
Yeah, so the kinds of examples here: keto products, low calorie claims, zero sugar. Right? As I talked about in another webinar, there is a pretty high risk of litigation when it comes to claims that you make about your product on your label or in your advertising. Those kinds of labeling issues aren't typically recall considerations, right? We're talking about circumstances where consumers may be misled, or at least are allegedly misled, but they're not getting hurt as a result of it, unlike the failure to disclose an allergen, which could cause somebody really severe injury or even death. So probably it's not a recall we're talking about. You might have a market withdrawal because of this. So the example I gave at the beginning of the product that's labeled non-GMO but has GMO soy in it, that's a problem. You have an out-of-spec product that you've now violated the warranties you've made to your customers that the product is labeled correctly. You possibly violated the contract that you have with the third-party certifier by putting a product out there that actually is GMO when it's not supposed to be, and has their certification mark on it. So you might have reasons to withdraw the product from the market, which could have a lot of the same consequences we've talked about, not the personal injury claims, but the costs and expenses of getting the product back from your customers. So yes, it's possible. How do you avoid this? Be careful about what you say about your product and make sure you can substantiate all claims and understand the legal standards that apply to those claims.
On that note, I would add two things. One is, with regard to the claims that you have on your label, like low calorie, those types of things, any function claims, that is basically uninsurable. Most insurance policies, if not all, exclude false advertising. They do not want to pay insurance claims based on your false advertising of your product. So lying or unsubstantiated claims. My best recommendation is work with a lawyer like Lauren to work on what claims are you making and how do you want to be making these claims. The other thing that I will say, and I have seen, wasn't a recall claim that I handled, but it was a product liability claim where it was an allergen label issue. And the fix of this was that the disclaimer about the facilities where this was made had to be near the same, the dairy-free label, that one was on the front and one was on the back. And the fix of this was that they both had to be in the same place so that that was very clear to the consumer. I don't know if that is, the standard practice at this point, but that is something that I saw a couple of years ago that might help mitigate that risk. But do know that this is one of the most common questions I get, the claims of natural and fresh and all of those things. You can basically not get insurance on claims against you for those being wrong or misleading.
Thank you. And then I dropped the webinar link that we did with Lauren past that she mentioned. It's here in the chat. If you guys want to open, I can add to the email too. So you guys can have access later. Okay, next question is it possible to have FDA review a recall plan to make sure that all important information is included? Also, where can I find FDA coordinator contact information?
So the first part of that, as far as I know, no. So FDA doesn't provide sort of like general consulting services like that. Your state might. So some state extension services have advisors on food safety issues and consulting services that you can take advantage of that might provide that service at no or low cost. But it's definitely the kind of thing you can hire a QA and food safety consultant to help you with, and which I strongly recommend that you do. There are a number of them in Startup CPG Slack community, and I think it's an important thing to have on your team, as I said before. The FDA recall coordinators, there is a whole list of them and their contact information on the FDA website. So you can Google it and find it pretty easily. There's a table with all the different district offices and who is the recall coordinator for each area.
Next one, what about claiming RTE berries that are known to be RTE? Is this misleading?
So I'm not sure what the question is. So RTE is ready to eat. I don't know why berries wouldn't be ready to eat. So I don't understand the question.
Yeah, if you can elaborate a little more for us, that would be great. Christopher asked, what are some things to consider before a brand manufactures themselves?
Lots of things. Yeah, I mean, there are tons of business things to consider, including do you have the resources to build a manufacturing facility and operate it? But there will be a lot more direct compliance obligations if you were your own manufacturer, right? So the food facility registration not only triggers that responsible party status for purposes of notifying FDA, but it also means that the preventive controls rules for food, which are a set of FDA regulations, apply to you directly. So it means you have to have a food safety plan that analyzes the hazards of all of the products and how you're going to control them, that you have a supplier verification program, and you'll be legally required to have a recall plan in that situation. And there's a number of other things depending on what the products are, but definitely there's an increased compliance burden if you're manufacturing for yourself. But you also have much more control over your product and how it's made and quality control. You have much more control over your proprietary information, your intellectual property, if you can manufacture your product yourself. So, there can be trade-offs.
From an insurance perspective, there's no difference. An insurance company is going to see the brand as the manufacturer, whether or not you contract the manufacturing out, because the liability is really on the brand, regardless of who's doing it for you or if you're doing it yourself. So from an insurance perspective, you're going to be rated the same. You're going to be seen as the same in the eyes of the insurance company, and you would want to have the same types of insurance policies.
Perfect. And then he added the raw berries are considered.
Yes, they are.
Okay.
Yeah.
Okay, cool. Well, we are on time. We got all the questions, but if you, Lauren, Danielle, can just say where people can connect you. I know we dropped the links in here, but is that the best way, or where they, if have more questions or want to hire you, how can they reach out?
So LinkedIn's great. The Startup CPG Slack is great. Lauren at handelfoodlaw.com. Any of those ways would be good for reaching me.
Yeah, I'm also in the Startup CPG Slack. My email is Danielle at ameliarisk.com. That's AMELIARISK.com.
Okay, perfect. Well, we will send the record tomorrow, so keep an eye on your email. And thank you so much for everyone that joined us. Thank you, Danielle, Lauren. That was awesome. I appreciate you sharing your expertise with our community.
Thanks, everyone.
Thank you.
Yes,
Bye.
thank you. Bye.
Bye.